For judgment, item number 1, JCRLA 60 of 2006.
The appeal is dismissed.
Item number 2, WPC 68 of 2008.
Writ petition stands dismissed.
Item number 3, WPC 30745 of 2011.
Writ petition is dismissed.
Item number 4, WPC 33492 of 2011.
The petition is dismissed.
Weekly list. All matter item number 1.
Item 1, no instruction, my lord. All right. No instruction.
Weekly list, all matter item number 2.
I know item number 1, appearance will be noted.
All right, all right.
May I please, Your Lord? Yeah, sir. Before I start off, I would like to draw your lordship's attention that in the state, due to mushrooming of trade unions in various districts, the industries are slowly closing down, MSME units. In Baleswar also, the same fate happened to Aditya Birla Group. That Birla Tires, it has also closed down. This case relates to Baleswar district. And incidentally also, because Bengal is near, I can only say after 1967, the proletarian concept of theory of trade unionism developed, and Mr. Birla had to shift after getting harassed on the road to Mumbai, relocated. Same thing happened with the Singhanias when they established the aluminum smelter in 74. They had to also relocate after some years. Here, my lords, what has happened? The reference which has been done by the state government as per Annexure 7 is under challenge. Annexure 1 is the Charter of Demand. Section 10.3 read with Section 12.5. Three things, my lords, are necessary so far as interference is concerned. There has to be a subjective satisfaction and an opinion has to be formed. Second, if there is a charter of demand, the reference should be in consonance with the demand. It cannot be any foreign materials or any ancillary irrelevant materials cannot form the subject matter of reference. And thirdly, the state government, while applying its mind, has not done so in the instant case. And there were 10 charter of demands, that is Annexure 1. One writ petition was filed, 2 writ petitions were filed with regard to the demand, one with regard to bonus, and the other is with regard to wages. Wages is before your lordship, that is WPC 6761.
No, but tell me.
6760.
No, 1 minute, sir. There are no workers, is it, as parties?
My lord? Yes, opposite party number 4 is the trade union who has been made a party. This
unit is still functioning.
Unit is a functional unit. It is unrecognized, unregistered, whose certificate has been cancelled due to fraud. Appeal went under Section 10B and subsequently district judge has upheld it. This union no more exists.
Then
the development,
then who will contest this petition?
Well, Lord, one development has taken place. That also I have given it the record. Your lordship may kindly see. On this ID case number 15, which has been registered, there has been both the parties, the management as well as the union, they have filed it for the purpose of withdrawal, to drop the reference. Then both the parties.
Then why should we go ahead with this then?
That is one. And second is to help your lordships out. The other writ petition WPC 6760, that order also I have passed, where my Lord Justice Javeri. The similar thing, this similar charter of demands, 10 charter of demands, 10 point charter of demand, one with regard to bonus was referred. This is with regard to wages. This is what he has also contended and he has disposed it off.
Yeah, so that's okay then. We say
6760 of 2004.
No, yeah. The present petition is 6761. Mr. Ratha, learned counsel appearing for the petitioner, has placed before the court copy of an order dated 29 November 2007 of the Industry Tribunal in ID case number 15 of 2004, recording the fact that a petition has been received from the General Secretary of the Union, bracket opposite party number 4 herein, bracket open quotation, to drop the proceedings, unquote, full stop. However, in view of the interim order passed by this court on 23rd August 2004, the said case, ID case could not be closed. Paragraph. In that view of the matter, the questions raised in the present writ petition have become academic. Taking note of the above development, this court disposes of the present writ petition and vacates this interim order to enable the consequential order to be passed by the Industrial Tribunal in ID case number 15 of 2004.
We'll list item number 3.
None appears. Dismissed. Revision STREV is dismissed for non-prosecution.
Weekly list item number 4.
May I please, your lordship? My lord, I am in BC.
Yes, Mr. Bhatt.
Here there is a delay of 5 years, my lord.
Okay. There's an inordinate delay of 5 years in preferring the present revision petition. The delay is not properly explained. Accordingly, MC number 118 of 2008 is dismissed. Consequently, the STREV is dismissed.
Weekly list item number 5.
Here also there's a delay. You have to unmute.
My lord, here the tax effect is rupees 37,000.
All right. With the tax effect being negligible, the court is not inclined to entertain the revision petition. Leaving the question of law open, the revision petition is disposed of.
Weekly list item number 6.
Item number 6, it is in fact similar to 6, 9, 10 and 12. My lord. These are Reliance Group matters, my lord. Here in all these 4 STREVs, the delay is of 365 days. My lord.
All right. You say there's a delay of 365 days, which is not properly explained. Consequently, the MC number, whichever is the corresponding number, is dismissed, and therefore the STREV is dismissed.
Weekly list item number 7.
My lord, tax effect is 9,000 somehow.
In view of the tax effect of being negligible, insubstantial, you say, the question of law is left open and the revision petition is disposed of.
Weekly list item number 8.
8, my lord, the tax effect is 38,000.
All right, same order. All right.
9, 10. Weekly list item number 11.
11, my lord, the delay is 1670 days.
Delay is 1670, unexplained. So it's disposed of. Dismissed for delay.
Weekly list item number 13.
My lord, MC 1286 of 2010 for withdrawal of the writ petition.
Withdrawal. Arch. The MC is allowed. Petition is dismissed as withdrawn in the manner prayed for.
Weekly list item number 14.
None appears dismissed. No prosecution.
Weekly list item number 15.
15, 17. Certified copy of the order impugned has not been filed.
All right. 15, 17. You see, despite 11 years having elapsed, even the certified copy of the impugned order has not been filed, and the defect remains uncured. Consequently, the writ appeal is dismissed for non-prosecution.
Lord, item number 14, I am appearing on behalf of the petitioner.
All right. Put his appearance. Right. Yeah. So his appearance is for Kurda municipality. You are for the petitioner.
I am appearing on behalf of the petitioner.
So tell us what it is.
Yes. Lord, the demand has been raised without complying with the mandatory provisions of law, which is prerequisites for assessing the valuation. The municipality has failed to apply the subsection 2 of section 43.
You are appearing for the municipality.
No, madam. I'm for the state.
Now, who's appearing for the municipality?
And
The 1 minute, sir. Who's appearing for the municipality?
provisions of 140.
Sir, who is appearing for the municipality?
Municipality BK Das, Vijay Kumar Das.
We'll wait for him, sir. Pass over.
Weekly list item number 16.
16, my lord, steps for limitation is not yet been taken.
Yeah. Despite 11 years, even steps for getting the limitation, delay condone has not been taken. The petition is accordingly dismissed. The appeal is accordingly dismissed.
Weekly list item number 18.
757 days.
The delay of 757 days, which is unexplained.
1920 similar to item 15.
19 and 20 similar to 15. Right. Dismissed.
Weekly list item 21. Item number 21.
21, I am for the opposite party, not respondent.
Made 3 minutes. Delay on the 5 days, madam. Though I have not filed it, or I have the challenge the order of court surfing adopted by the respondent.
No, in 21, you are for the appellant.
I am for the appellant.
Ha.
Challenge is to the practice of court surfing in the High Court, my lord. Petitioner filed the petition saying that I am entitled for better marks. Therefore, the court directed.
So now it's infructuous, sir.
Yes, and limitation, so far as limitation thing is
5 days limitation is there.
No, but even otherwise, it's 11-year-old matter, sir.
My lord.
There's no stay, nothing.
No stay, my lord.
So you said due to effects of time, the delay is controlled. Due to effects of time, the petition has been rendered, appeal has been rendered infructuous and is disposed of.
Thereby, the practice of court surfing would be confirmed, my lord.
Sorry?
Practice of court surfing would be confirmed by this honorable court.
here.
One judge has denied. One judge has denied the relief. He has approved the other judge.
May I submit, Miller? May I submit, Miller? Here, your lordship, your lordship may kindly appreciate if a student has been suffered because of the latches of the university, he was made fail.
Sir,
he was a first student.
Of the appeal,
Now,
why is arguing?
on the technicality, my senior is
The appeal has
challenging.
been disposed of, sir. All right.
Weekly list item 22. Weekly list item number 22.
None appears. This was no prosecution.
Weekly list item number 23.
23 delay of 697 days.
Ah.
24 700
23, 24, all unexplained delay.
and 25 is 698 days.
All right. All dismissed.
Weekly list item 26.
None appears. This was no prosecution.
I am for the opposite party.
All right, sir.
Weekly list item number 27.
None appears. This was no prosecution.
Weekly list item number 28.
May I please, your lordship? In this case, my lord, the petitioner challenged the order under Annex 3, my lord, wherein the order has been passed without giving any opportunity of hearing to the petitioner. She is the affected party, my lord. Annex 3, my lord. Page 12. My lord, initially the case is like that. Initially the recorded tenant is Dhruvacharana Naik. From Dhruvacharana Naik, another person has been purchased that land. That land has sold to the petitioner. The petition, wherein the petitioner is in possession, under resumption case, the lease has been cancelled.
Without hearing you.
My lord.
Without hearing you.
Without
Here
hearing
the
you.
lease was granted in 1980.
Ah.
The sale was effected in 1982
Oh.
to the present petitioner, and the order was passed in 1984.
Oh.
But the original lessee was heard.
Ah.
But it is clearly so that original lessee has been had. So far as the petitioner is concerned, she has not, no notice has been issued to her. So this,
Well,
this
it's not
statute
a
says-
valid
My lord,
purchase.
your lordship, may kindly have glance subsection 3 of the, I have quoted in the body of the petition, my lord.
The sale could
Page
not,
four,
could not
page
have
four.
been effected within 5 years of grant of lease.
Correct,
Madam.
correct.
Provided that no order shall be, my lord, page 4, I have quoted that provision, my lord. Provided that no order shall be passed under the subsection unless the person affected by the
I know, sir,
purpose-
but the person affected came into the possession only by legal sale deed
Yes.
after the cancellation of the lease. If it had been before the cancellation, what you say is right.
No, in the 84, the lease has been cancelled.
No, 80.
No, my lord,
No,
84, your
granted-
lordship,
lease
your
granted
lordship, Annex 3.
Lease granted in 80, my lord.
Oh.
The sale was made in 1982.
Ah,
The cancellation is in 84.
oh, then she has to be heard.
Yes.
All right. I thought it was the other way.
Well-
Okay. The petitioner is a purchaser from a lessee whose lease has been cancelled by the impugned order passed by the Additional District Magistrate Bhubaneswar in lease revision case number 230 of 1982 on what's the date? 7/4/1984. It is evident that the order was passed without hearing the petitioner. On that short ground, the impugned order is set aside, and lease revision case number 230 of 1982 is restored to the file of the Additional District Magistrate Bhubaneswar. The petitioner will now appear before the ADM Bhubaneswar, along with the downloaded copy of this order, on 16th May 2022. The ADM will endeavor to dispose of the revision case within 4 months thereafter. Till such time, the status quo order passed with this court on 9th September 2011 will continue. The petition is disposed.
But as it appears, my lord, no interim order is there as per our file record.
No. 9th September 2011 is status quo order.
All right.
Right.
Weekly list item number 29.
None appears, dismissed for non-prosecution.
Weekly list item number 30.
None appears, dismissed for non-prosecution.
Weekly list item number 31.
My lord, I am for the petitioner in the tagged matter method that has been tagged, that is WPC number 18,564 Miller.
Correct.
So I will argue this matter, Miller, on behalf of the landlord, Miller. The original number, that is 22,000 something, that has been filed by the landlord, Reliance James, sorry, my lord, that has been filed by the tenant,
right.
That is Reliance James and Jewelers.
Right.
But I have filed my application is 18,564 of 2011, Miller.
Right.
So I am for the landlord, Miller.
Yes.
So, Miller, if my learned friend argue the matter that is 22,000 something, thereafter, Miller, I may be permitted to argue my matter that is on behalf of the landlord, Miller.
All right. Who's for the tenant? The tenant is not appearing, sir. So that will dismiss a non-prosecution. You appear. You argue your matter now.
Yes, Miller. I will argue for the landlord, Miller.
Yes.
My matter is 18,564, Miller.
The matter you say none appears, dismissed for non-prosecution. The first.
My lord.
388.
May it please your lord. My lord, I am the landlord of the house in question, Miller. I have let it to the tenant, that is Reliance Gems and Jewels, on a monthly rent basis. Before opening of my shop, Miller, I was issued by the Deputy Commissioner of Police the notice to not to allow the house to be utilized for commercial purpose. That is Annexure 1, Miller. So in pursuance that, in reply thereto, I submitted my so-called reply, that is Annexure 2, Miller. So, Miller, Annexure 3 is legit, Annexure 4 is the letter on permission issued by Electricity Board, and Annexure 5 is the trade license issued by Bhubaneswar Municipal Corporation. Annexure 6 is the invoice and bills, and Annexure 7 is the plan letter issued by the Bhubaneswar Development Authority allowing my building for compounding. I deposited the compounding fee, and the building has been allowed to be utilized. Your lordship may see Annexure 7, that is for residential oblique commercial purpose. I am utilizing as per the permission granted. That ground floor is the commercial purpose, and the first floor has been used as an office of the same tenant, Reliance Gems and Jewel, and the storeroom to which no customer is having any access. And Annexure is the impugned order by which I was restrained and obtaining the stay order from this honorable court. The storeroom is functioning since last 11 years, and I have never been issued a notice on behalf of the Commissioner of Police that there is a single case of violation of traffic rule or that parking of vehicles, either four-wheeler or two-wheeler, in front of the showroom during the last 11 years. Not a single has been noticed to me, Miller. Miller, I want to submit here, Miller, that the opposite party, that is Deputy Commissioner of Police or Commissioner of Police, they have no right, because I have been permitted by the Bhubaneswar Development Authority according to Annexure 7, to utilize my building for commercial plus residential purpose. So the ground floor is commercial and the residential, which is, I mean the first floor, which is being utilized for office and storeroom, though it may be commercial, but that is also not strictly commercial because that is not nothing transaction takes place there. And the second floor is lying vacant, and the third floor there is only 6 feet square feet structure only. There is no joint and boundary, nothing is there attaching the staircase room, stairhead room, my lord. So, my lord, in the background, my lord, I will press for 3 to 4 points, my lord, for your lordship's consideration, my lord. My lord, first is that, as I have already submitted, in the last 11 years, there has been not a single case attributing the traffic congestion or problems due to operation of Reliance store, gems and jewel store on the particular spot. The number of customers to their jewelry store and gem store is very, very limited. So there is no question of any rush and parking. Second is the location of the store or that building is 300 feet away from the intersection of the road. So, my lord, in that case, there is a footpath dividing the road and my shop. I mean my building, my lord. And there is also 2 electric transformers. And moreover, my lord, in the corner in front of my house, there is a tent put up by the police personnel and 3 to 4 police personnel staying always there to control the traffic, my lord. So, my lord, the apprehension by the police authorities by the Annexure 1 and the consequential order by the Annexure 8 has no legs to stand, my lord. And that to my lord, next point is all neighboring houses on the both sides, my lord, all the houses. No, not a single house is being used for residential purpose because at the present stage, my lord, this area is so crowded and so vehicular, number of vehicles are flying, my lord, it is unfit for residential purposes, my lord. So not that my case is singled out. So this must not be permitted to be done by the police commissioner. And next point is, my lord, I am provided dedicated parking as per the plan, my lord. BDA, Bhubaneswar Development Authority, that is Annexure 7. My lord, I am sorry, my lord. I am sorry, my lord, that I have not, I may pardon, my lord. Just a minute, my lord. 1 minute, my lord, I am. Yes, my lord. Sorry, I am not an expert, my lord. So my next point is that, my lord,
You are on mute, sir.
Your video is also off.
Lord, I am pardoned, my lord. I am out of link, my lord, because of my mistake, my lord. I may be permitted to submit on some other day. I will follow the rules. I am very, very sorry, my lord. I am very, very sorry, my lord. Hey, Gauri! Hello.
Pass it over. Just tell him it's passed over. Just come back.
Weekly list item number 32.
My lord, in 32, I may be pardoned. I tried to, my lord, in fact, my record is not available. I tried to verify your lordship's record, which I could not succeed. My only apprehension is here counter and everything has been filed. It may, some substantive right may be involved. May I only pray for next week so that I get a chance to verify your lordship's record and
We'll just tell you what it is. 1 minute. No notice has also been issued, sir, so far. In this.
But the list shows that counter has been filed, your lordship.
I know. Some install, not to install transformer and make measurement and demarcation of land. But no interim order, nothing, sir. It's an 11-year-old matter.
Your lordship may grant liberty, my lord, because it's a right to property.
It
Maybe
appears
they are
that,
enforcing
it appears that the subject matter of the petition being such, the petition may have become infructuous by now, leaving it open to the petitioner to file a fresh petition if any cause of action survives. The petition is disposed.
Deeply obliged.
My lord, I may pardon me, lord. Because of my mistake, I am not expert, my lord. I called my son and he now helped me. And I have make that call. No call will come, my lord. Do not disturb. Please, I may be permitted to continue my argument, my lord.
Yeah, you
I
continue.
you
complete your submission. You already made your submission, so you just complete it.
My lord, other points are there. Other points are there. The next point is that, my lord, the customers are very much limited and Reliance shop has provided its security staff, my lord, security personnel to ensure that there is never a single vehicle parked in the road and in front of the shop, my lord. So, my
Sir,
lord,
they simply say that if they propose to take action, they'll give you 10 days advance notice. It's all right. Because this is something that happened 11 years ago.
Yes, my lord.
So we will say that if they propose to take any further action against you, they will give
yes,
you 10
my
days
lord.
notice.
My lord, oblige me, lord. And the interim order may allow continue not to take any courtesy measure, my lord.
In this case, I am appearing for in the secondary petition and the intervenant in the first, your lordship. I am for Reliance Gems, Jewels and Gems, your lordship.
Oh.
So I am been affected in substance.
So we'll ask them to give you 10 days notice.
Yes,
sir.
may I submit one thing, your lordship? 2011, the order was passed. Interim order continues to lead, as my council has said. But in the meanwhile, there was orders passed by the BDA as well as municipality, your lordship. Whereas my it has development plan was building plan was approved, as well as the municipality has granted us license for operating of shopping. These facts were not brought before the DCP. Let them take up fresh.
Sir, you are not listening.
I'm listening, your lordship. I'm there, your lordship. Is my humble submission is that 10 days
disposed of with the direction that in the event that the DCP traffic proposes to take any coercive action against either of the petitioners, 10 days advance notice will be given. This order is being passed because the earlier order passed by the DCP has been stayed by this court, and that stay has continued for over 11 years now. Okay. The petitions are disposed of. So that's what we have said.
Yes.
That coercive action not being taken is continued till date.
My lord, oblige me, lord.
May I add one thing, your lordship? So-cause notice may be given so that we'll give
10 days notice. We have said we can't even now sit and dictate what should be the title of the notice. All that we are not going to do here. Yes.
Lord, kind permission, but second matter, I was appearing, Lord, the consent has been given, so my name may be kind.
All right.
Grateful. Weekly list item number 33.
None appears dismissed now. Both matters.
Weekly list item number 34.
None appears dismissed now.
Weekly list item number 35.
May I please, your lordships? Here, my lord, the petitioner challenges the impugned proceeding under Annex of 5, my lord. That is Regulation 3B, Regulation 2 of 9656, Section 3B, my lord. This matter has already been decided by this Honorable Court in Division Bench, my lord. Reported in 2019 to OLR page 94, my lord. In case of Jami Ramesh and others versus State of Orissa, my lord. Here, my lord, Regulation Section 3B of Regulation 2, 1956 is prospective in nature, not retrospective in nature, my lord. The transaction which were there prior to my lord 4/9/2002, they need not be.
All right. Where is the judgment, sir?
My lord, I have.
Para 12 and 13 is the relevant.
All right. In view of the judgment of this court dated 12th April 2019 in writ petition civil 14733 of 2006 bracket Jami Ramesh versus State of Orissa and batch. The impugned show cause notice dated 21st November 2011 issued by opposite party number 1 in OSA TIP case number 15 of 2011 is hereby quashed. The petition is disposed of.
Well, the sub-collector to take a fresh decision as per the judgment.
This will not prevent the opposite party number 1 from taking a fresh decision in accordance with law.
Yes.
Weekly list item number 36.
36. Ex parte order, my lord, annexure 3, running past 10, my lord, under section 7A3 of the OGLS Act, my lord. Annexure 3, running past 10, my lord.
You're a purchaser.
No, my lord, here it appears to be some discrepancy, my lord. Here the petitioner is Sanat Kumar Samantray, SANAT. Annexure 1 is, my lord, document C, page 7, Sarat Kumar Samantray, first page. And the impugned order pertains to Sanat Kumar Mishra. So I don't know why he has annexed 3 different documents.
Therefore, you withdraw to file a proper petition, sir. Yes. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a proper petition according with law.
I am a Sanat Kumar Samantray.
All that, to file a fresh petition giving all the correct documents, sir.
That is the wrong order, my lord. That my title
Whatever
is wrongly mentioned,
done,
my lord.
you have to explain all that, sir.
That should be corrected by the ADM, my lord.
Whatever you apply there and get it corrected. All right.
Weekly list item 37.
37, my lord. This is also ex parte order, my lord.
This is also the same thing, my lord. Some discrepancies there. The petitioner is Nirupama Mahapatra. The lessee, original lessee is Bidyadhar Swine.
My husband, my lord. Husband died, my lord. Therefore, I will submit a document, my lord. The death certificate and legal heir certificate also.
And the other legal heirs are not on record, my lord. They should also be made parties.
Only wife is the party.
No children, nothing.
Why?
Are there other legal heirs or not? That's the question.
Other legal heirs, my son and daughter, my lord.
So they have to join you then.
The wife.
Counsel the petition again seeks leave to withdraw this petition with liberty to file a proper petition according with law.
Item number 36, my lord. My name is wrongly reflected in the.
I know, but you'll have to go there and get it corrected, or you have to explain it, sir. Yes.
Weekly list item 38.
May I please, Your Lordship? I have lost the brief. Your Lordship, may kindly permit to hold the brief of Your Lordship. I have challenged the annexure 1, Your Lordship, that is page 14 and internal page 18. But the development fact is that a group of applicants have filed a section 33C2 application. During pendency of that case, the union leaders are bound alive the higher authority of the management. So it was declared as a lockdown. And subsequently, on basis of the settlement arrived between the parties, including the entire workman, representative, and the management, it was settled that all the matter will be settled, the unit will be function, and all financial benefit and accordance with law will be given. So accordingly, we have filed a joint petition before the Learned Labour Court, Your Lordship, as page 6, page 45, annexure 6, Your Lordship.
So what's the grievance?
So the Learned Labour Court has rejected the petition, saying that since the union leaders have not signed the settlement forms, so it is not acceptable.
Who's for the union? Who's appearing? Have they been served?
As per my information, union is not functioning also.
Then it's all infructuous, sir. Counsel, the petitioner informs the court that the union which to raise the dispute is no longer functioning, thereby rendering the entire dispute infructuous. The petition is accordingly disposed of.
Lordship, kindly direct the Learned Labour Court to pass according.
Yeah, it will be open to the petitioner to request the Labour Court to pass consequential appropriate orders.
Yes. Oblige, Lordship.
Weekly list item number 39.
None appears dismissed.
Weekly list item number 40.
40, we have filed IA number
miss case number 86 of 2015
Ah.
for recall of order, because that by that order, the writ appeal was dismissed for non-prosecution.
Hmm.
And in fact, the certified copy was not filed. That is why this
Ah.
was rejected. So,
But even today, no certificate.
no, we have also filed. In the meantime, we have filed the certified copy, but there is delay of 2 years in filing. About 2 years in filing.
So the recall application is allowed. In the main writ petition, you see there's a delay of 2 years, 5 days in filing.
Yes, 2 years.
Which is unexplained. The appeal is accordingly dismissed on the ground of delay. Right.
I may be pardoned, my lord. Item 26, my lord. If you lordship are kind enough to heard the matter after this is.
Say, can't understand.
You're not audible. Not audible.
I mean, pardon, my lord. Item 26, my lord, the present list, the old matter, my lord. Which is, I cannot be reached, my lord, that lordship can kind enough to heard the matter after recess, my lord.
I'm not able to understand what you're saying, sir. You have to speak loudly.
My lord, item 26, today's list, my lord. I could not reach, my lord, that matter man kind enough to hard, my lord, after recess, my lord.
Why recess? We're here right away.
This is a matter, my lord. I'm challenging the ombudsman's order, my lord. The contention is that, my lord, there is a provision in the regulation to allow time of day, the TOD benefit to the consumers, my lord. And both the lower forum, my lord, GRF, grievance redressal forum, and the ombudsman had allowed my prayer that I'm allowed to provide, the licensees were directed to provide TOD benefits. The licensee is the opposite party. They have not challenged that order, my lord. That implied state they have accepted that order. Only question is that the ombudsman directed that the TOD benefit was provided to me by the licensee should be distributed 50-50. 50% to me and the rest 50% to the licensee. But there is no such provision in law, so far as the regulation is concerned, that 50% is allowed to the licensee. That is the sole question.
But there's no stay order, I think. Is there a stay order here?
No, my lord. We have only challenged that whether I am entitled to the 100% of the TOD benefit or 50%.
No, the other side has already got the 50%, sir.
But the ERC specified that if I am entitled for TOD benefit, that is.
So once there is no stay after 11 years, now to ask them to return the TOD benefit will be difficult.
They have allowed for 50-50.
Correct. So let it be that way, sir. Every matter we don't have to interfere.
There is,
since there is no stay order passed by this court, the impugned order has already worked itself out, in terms of which the petitioner and opposite party number 3 will get 50% each of the TOD benefit. Since 11 years has elapsed, the court is not going to change, not inclined to change the status quo vis-a-vis the TOD benefit at this stage, leaving the question of law open for consideration some other case the petition is disposed of.
Disposed of my on the light of the ombudsman order, my lord.
That's right. That's what it means. Yes.
One pass over. Weekly list passed over matter item number 14. Item 14.
Pass over item 14. But in this case, I have stated that the holding tax has been assessed without complying with the mandatory provisions of which are precondition for assessment.
Who was
of
appealing for
tax.
Kurta? Nobody. Okay. All right. Yes. Holding tax has been levied without
Complying with the mandatory provisions of law, that is section 143, 144, 152, and I have stated that in my grounds. So that the manner has been prescribed. And 1975 Supreme Court says that where the manner has been prescribed, it should be done in that manner only. Here, they have not done according to the law, and no counter has been filed. Therefore, my submission is principle of non-traverse applies here. Counter has not yet been filed, and they have not produced the document which has been passed ordered by this honorable court at the time of admission.
All right. You say the challenge the present petition is to
Lord, kindly
demand.
see one paragraph, my lord. Though the municipality lawyer is not appearing, my lord, I'm appearing for the ADM, my lord. The appeal, he had preferred an appeal. Appeal has been dismissed. Lord, kindly see Annexure 5, page 21. Here, the appeal was preferred by the petitioner, challenging the assessment made by the, my lord, executive officer of the Khordha municipality. Lord, see page 21, second paragraph, my lord. The advocate appeared for the executive officer Khordha municipality, submitted that all the procedure has been followed by the EO while assessing the annual value of the holding. The determination has also been made as per the estimated cost of the construction furnished by the petitioner himself. So he had furnished the my lord, particulars basing upon which the assessment has been done.
But
I'm
that
just
is
pointing
not
at-
correct because the construction has not been done. The erection has not yet been done, and they have not taken the valuation of the construction during that period. That is my contention. And kindly see that has been mentioned in my ground also. Ground number, kindly see. There are page 7, ground number 8. Non-compliance. It is submitted that provisions of subsection 2 of section 143 has not been complied with. Last para. Well, next, J, page 8. Non-compliance of section 144. Next, ground number K. Non-compliance of the provisions of section 145. Well, L. No notice has yet been served under section 152(2). Therefore, the manner has been prescribed and it was not done in that manner, prescribed manner.
Let it go back. That's only. This is the challenge in the present petition is to an impugned order dated 18th August 2009, passed by the Additional District Magistrate Khordha in Municipal Appeal number 1 of 2009. Stop. By the impugned order, the appeal filed by the present petitioner against the assessment of holding tax by the Executive Officer Khordha Municipality was dismissed. Paragraph. The short ground in which the impugned order is assailed is that it was passed without affording the petitioner an opportunity of being heard. Although it is contended that the annual value of holding has been determined on the basis of the estimate costs furnished by the petitioner, the fact remains that no notice was issued to the petitioner prior to fixing of the determination of the holding tax to be paid by the petitioner. On that short ground, the impugned order dated 18th August 2009 of the Additional District Magistrate Khordha in Municipal Appeal of 1 of 2009, as well as the assessment order. Which date is the assessment order? You have the assessment order.
Well, Annexure 5 is the order.
No, Annexure 5 is the appellate order.
Annexure 4, page 18, madam.
Appellate order. Annexure
Page
4.
18.
And the corresponding
Annexure 4, page 18.
order dated 30th April 2009, along with the demand bill, are hereby quashed. Paragraph. The matter is remanded to the assessing officer to determine afresh the tax payable after hearing the petitioner. For this purpose, the matter will be listed before the assessing officer on 18th May 2022, on which date the petitioner will appear through an authorized representative, along with the downloaded copy of this order. The assessment proceedings be endeavored to be completed within 3 months thereafter.
Supplementary list. For orders item number 5.
So no coercive action shall be taken till disposal of the appeal after remand.
It's all right. Yes.
Supplementary list for orders item number 5.
None appears to switch numbers.
Supplementary list for orders item number 6.
None appears to switch numbers.
Supplementary list item number 7.
Item 7, your lordship permitted to withdraw.
Council petitioner seeks leave to withdraw the present petition. Dismisses withdraw.
Supplementary list item number 8.
Yes, my lord. May I plead, my lord, matter relates to my lord consideration of my lord petitioner challenged the virus of the notification, my lord, 2016 and 20 rules, my lord, only to get his appointment under rehabilitation scheme, my lord, in 1990 rules, my lord. So notice may be issued, and in similar case, your lordship already issued notice and counter already filed
Where is that?
in WPC number 14,078 of 2020.
List along with 14,728
Yes.
of 2000.
WPC number 14,078, 14078 of 2020.
On which date is it coming, sir?
That is not known to me, my lord. Let it be listed with that matter along with that counter.
On 27
Counter
July.
already filed, my lord.
27 July. Right.
In this case, a copy may be served.
Yeah. Copy.
Yes,
served
in
on
course of
Mr.
the.
Mahapatra.
Yes, sir. Only.
Supplementary list item number 9.
Yes, sir. May I please, my lords?
Yes.
Yes, in this case, petitioner challenges Miller's notice under section 148 of the Income Tax Act as well as Miller's pre-proceeding order under 148A of the said Act, Miller's. Miller's, as my lords knows, earlier a batch of cases was also before lordship, Miller's, in the case of the petitioner is that under section 148A, which has come by amendment, before initiating notice under 148, an opportunity of being hard is to give Miller's.
Yes.
So your lordship the other day wanted to know whether mere issue of show cause notice can at all be constituted to be an opportunity of being hard when no opportunity of hearing is granted.
Right.
Plus, here, notice I have annexed Miller's annexure 1, 7/3/2020, page 13 Miller's, page 1-3. And responding to this notice, Miller's, your lordship will find I filed one application which is uploaded seeking adjournment, that is by the annexure 2 at page 15. Your lordship will see seeking adjournment request to notice successfully submitted. And Miller's, thereafter by the annexure 3 on 23 March, Miller's, I have submitted my explanation along with documents, Miller's, annexure 3 Miller's. Thereafter, annexure 4 is passed on 26/3/2022, where Miller's, the opposite party number 1 says that you have not furnished any reply, even though annexure 3 is submitted pursuant to annexure 1 Miller's, he says that. And apart from that, my specific humble submission before lordship is Miller's, an opportunity of hearing, that is a mandate of law, it is mandatory, and I have quoted the provision on page 6 of my application. Your lordship may kindly see for a moment. Section 148A, Miller's, I have reproduced that paragraph at page 6 of my application. 148A, Miller's.
Yes.
Conducting inquiry, providing opportunity before issue of notice under section 148.
Let's ask Mr. Mahapatra.
My lord, after 148 notice is issued, my lord, no reply was given. My lord, whether prior to that inquiry was conducted or not, my lord, any opportunity was given or not, my lord, that has not been shown. Thereafter, my lord, 148 notice has been issued.
No, I think 148
notice,
makes up for the GK and drive shafts.
Yes, absolutely correct.
GK and drive shafts.
I am giving a copy of your lordship's order to my lordship. Your lordship have passed in similar matter. I am giving a copy to your lordship. My lordship kindly see. That is order dated 4/4/2022.
Achha, it's coming up for the first time.
Yes, my lord, I will
This is coming for the first time.
Or notice, Mr. Mahapatra accepts notice. Till the next date, no further coercive steps should be taken. We'll list it on the same day, 4th May.
4th May. Your lordship have said no further steps are taken pursuant to improve notice against the petitioner.
Yes, that same order we passed.
Much obliged.
List on 4th May along with writ petition civil 8217 of 2020.
Yes,
right.
8217 of 2022.
Right.
Obliged.
Supplementary list item number 10.
My lord, pass over, my lord.
All right.
Supplementary list item number 11.
Item 11, your lordship may pay for Passover.
All right, pass over.
Mobilized, your lordship.
Supplementary list item number 12.
None appears dismissed from office.
Supplementary list item number 13.
None appears dismissed from office.
Supplementary list item number 14.
In this matter, they have not filed any reply.
Who's for the yourself? Item 13. 14, sorry.
14, my lord. The counter has not been filed, my lord. He's challenging a circular of 2013, my lord. Which may grant me some time, my lord. The new rule has come into force, my lord, in 2013. I take instruction.
The result, the interim order was result of recruitment for post of village level workers. This is 2013, sir.
Yes, madam.
But lordship, still you are working at Gram Roja Sevaks, lordship. It is a post under the Gram Panchayat, and the recruitment rules should be followed, taking into the consideration total employees of the Gram Panchayat,
That's
lordship.
true. You have stalled the recruitment now.
No, we have not stalled, lordship. They have already given effect to, but the interim order there, any appointment, lordship, that is perhaps that is there.
Yes.
But lordship, they have already given promotion. I am still working at a Gram Roja Sevak under the respective Gram Panchayat, lordship.
So after 11 years, what will happen? Suppose you succeed in this
Yes, lordship,
petition.
it will succeed definitely, lordship. Now they have, in 2021 also, they have come up with the new rules, giving the same advantage to the VLWs and dividing the employees of the Gram Panchayat. It is clear violation of Article 243G, lordship, because it is enabling provision. The state government has come up with the rules. They are dividing their own rules, lordship. Lordship, kindly see that I am reading one paragraph of their rules. They are saying the engagement will be affected by the PRA bodies. Government will have no role to linkage to the engagement of these personnel, deployment and other related matters. So it is a post under the Gram Panchayat, and in view of the Article 243, the government should not interfere with these affairs. And the rules come up only to accommodate the employees of the Gram Panchayat to the regular posts. But by means of this amendment, lordship, this notification, they have taken out the entire right. Only are they giving 30% preference to the Gram Panchayat employees, and they are taking 70% from the fresh candidates. So it is contrary to their own law. So they should file their counter, lordship. They should respond to their allegations, lordship, because all the Gram Panchayat employees of the state are being affected by of this order.
In view of the coming into force of the 2021 amendment, my lord, probably my learned senior needs to amend the
Yeah.
Yes.
File a fresh petition,
No,
sir.
lordship. Because it has to be answered. That is also under challenge, lordship. 2021 notification.
Where have you challenged that?
Lordship, that is, I will give the numbers. That is in different date application, it is under challenge, lordship.
So we'll take it with that, sir.
Yes.
But lordship, kindly see, in this writ application, we are challenging 2013 notification.
That doesn't
Had it been
survive any longer,
lordship,
sir. That
no, lordship, if it will be
2013 doesn't
allowed,
survive.
lordship,
Because of 2021 regulation.
21 is complete. 21, they have divided us. They have fixed age criteria. They have fixed 45 years the upper age limit. That's why we challenge that notification, because we have completely given, restricted us to participate in the interview. That is the complete separate notification. Here, lordship, if I succeed in this application, in since 2013, I will go and observe with the regular post, because the vacancy still lies with vacancy lies, lordship.
No, how will you directly get absorbed? I don't understand.
My lord, they cannot.
How do you directly get absorbed if you filed succeed in the writ petition? I don't.
Lordship, they come up with a new rule, 2008 rules, lordship, observing all the Gram Panchayat employees in the regular post. But 2013, this ISF sir came with a notification, making category of 70 by 30%. That is under challenge. Because the government, state government has 2008 have come up with the rules.
No, what has happened in 2021? Let's be clear on that.
21 only they have fixed the upper age limit, lordship. They have come up with a new rules, and they have fixed the upper age limit and dividing the entire Gram Roja Sevaks, lordship.
Unless you succeed in the next writ petition, there's no point in succeeding in this, sir.
No, it is here you are challenging 2013 order, lordship. Both have
No, but in view of a 2021 rule that fixes an upper age limit, you cannot, without succeeding in that writ petition where you've challenged the 2021 rule, you can't succeed in this
Some of the
writ petition.
petitioner would automatically be disqualified.
No. 2021, that has been stayed, lordship. Lordship stayed that order, that notification. Lordship stayed 2020 notification, that has been stayed.
Where is that order, sir?
Lordship, lordship, let it be tomorrow, I can, lordship.
All right, at the request of Mr. Dalai. Order to continue.
23rd July Lordship. Then Lordship, at the same time, they should also come up with a counter Lordship, it will be better Lordship.
Yes. I don't know, it's up to them. So 2021, we have to really concentrate on that, sir.
In fact, Lordship kindly consider one aspect,
See,
Lordship.
if you do not succeed in the 2021 challenge, nothing
I will
will
succeed, Lordship, here. Because Lordship, prima
So
facie.
first you do that, then we will talk about
But
this.
Lordship
Sir,
kindly
look
consider
at
one
the
aspect.
scenario.
Lordship.
Suppose you succeed in the 2021 writ petition, we'll take this up.
Lordship.
Suppose you fail in that, there's no point in taking this up.
But Lordship, in that case, Lordship, if I will succeed in this application, I will get benefit not since 2013.
See,
but
you're putting cart before horse, that's the problem. If by age you're disqualified, then you're out anyway, sir. But by age, if you're not disqualified, then we will take up this.
These writ petitions are not coming on the disqualification, Lordship, because we are challenging 2013 notification.
Anyway,
If at all we succeed, Lordship, we will get the benefits as per 2013 rules.
All right.
Supplemental list item 15.
My lord, item number 15 kindly pass over.
All right.
Supplemental list item number 16.
16 materialist to compulsory retirement, they have noting that they have filed the counter, but copy not served, for which I have not filed the rejoinder.
Copy of the counter will be served on the petitioner within 3 days, rejoined for the next date. List on 5th September.
Within a week, I shall file the rejoinder.
Supplemental list item 17.
None appears dismissed from opposition.
Supplemental list item number 18.
Madam, in this case, on the last occasion, your Lordship has called for certain instructions plus that I have supplied to your Lordship. The instruction is the school building is almost all complete in all respect. And within next 2 months, the construction company will hand over the same to the concerned school.
None appears for the petitioner. On Mr. Katkia, appearing for the opposite parties, has placed before the court written instructions received on 8th April 2022 from the Tehsil office, Methli, stating that the Eklavya Model Residential School, Mendukuli, is almost complete. That matter, no further directions are called for the petition.
I am opposite, but number 1.
All right.
Diplo obliged, please.
All right.
Supplemental list item number 19.
Please, Your Lordship. Madam, in this case, the petitioner has challenged the select list minor under Annex 1 in respect of the clerk cum copyist conducted by the Judgeship Kemjor minor. My Lordship, kindly have a glance the notification under Annex 7, page 16, my lord, by which my lord notification was made inviting application for the post of junior clerk cum copyist, item number 1, page 16, in which my lord total number 13 number of posts are vacated for to be filled up, and my lord, out of which my lord 4 number posts are unreserved, 3 number posts are for SCBC, 2 number posts for SC, and 4 number posts for ST. And in view of that, petitioner having requisite qualification applied, and also his application was scrutinized, and he was intimated to appear written examination, that is under Annex 8, page 25. And in English, mathematics, general knowledge, in written examination, he came out successful. Thereafter, he was invited to attend the computer science test and Viva Voce test, and in which my lord, he was successfully, my lord, complete the same. And a panel of list, merit list was prepared, that is under Annex 10.
Which category do you belong to?
Pardon?
You belong to which category?
SCBC category, my lord. SCBC category. Page 10, my lord, page 27, Annex 10. Lordship have a glance. The merit list was drawn up. In the merit list, my lord, petitioner placed at serial number 13, my lord, Iswa Bhushan Mohanto, SCBC. What happened thereafter, my lord? Though the merit list was drawn up,
the opposite party, my lord, prepared a select list, totally bypassing the reservation, Orissa Reservation Act and the act enacted by the government in respect of the SCBC category, my lord. And also the law already settled by the Honorable Supreme Court, my lord, in the case of Indira Sahni case, my lord, that the persons, those are coming on merit, my lord, they shall be given, they shall be selected in respect of UR post. Or here what happened, though the persons, SCBC candidates coming within the merit, they have been shown
against SCBC.
SCBC.
Yes, what do you say, Mr. Mudali?
Your Lordship, may kindly, first of all, this annexure 1 at page 10, he challenging this list so far as junior clerk cum copyist is concerned. Your Lordship, can see there are 13 persons have been selected and none of them have been made as parties. And second thing, this was published on 8/1/2021, more than 1 year and 3 months back. As per sub-rule 6 of rule 7.
See, the affected parties have to be made, affected candidates have to be made parties, sir.
In that regard, my lord, my expert Swami Lordship, my lord, the very part of time that list was challenged, no appointment was given. Appointment was not given at the relevant time.
No, but since then there have been persons appointed.
So it is also, Lordship knows, my lord, it is very difficult on the part of the petitioner to obtain the address.
No,
the home address.
The organization will know the address.
And this select list has also expired in the meantime.
But prior to that, she had challenged. Just after publication of the list, and the interim order, Lordship also passed.
No, interim order is only that will be subject to the outcome of the writ petition.
Yes, ma'am. Yes,
no, but still have to hear.
Ma'am.
Persons who will be affected have to be heard, sir.
Ma'am.
Counsel, the petitioner seeks leave to amend the writ petition to add the affected persons. At his request list on 7 July.
Oh, right.
I don't mention Milo. Item number 17, Milo. That copy of the counter has received on today only.
17 today I am filing the counter.
Item 17. Mr. Mudali states that he'll be filing the counter favor during the course of the day. Rejoinder will be filed for the next day.
Pardon to mention, my lord.
1 minute, please. 1 minute. List on.
May I please, Your Lordship?
Sorry. 27 July.
Pardon to mention, my lord. One item 18, I am appearing for the petitioner. At the same time, both the matter clashed together. I mean, another.
Tell us what it's about.
Non-appearance was mentioned.
Tell us what is it about. Yeah, that school has already come up, sir. You can give a copy of the letter to it. School has already come up.
Yes, sir.
All right.
Just our non-appearance may kindly be deleted.
All right. Take off that non-appearance of this.
Oblige, my lord.
May I please, Your Lordship?
20 on last two occasions, so Lordship has granted us time to file counter, my lord. Lord, as a last chance, so Lordship may grant us 2 weeks more, my lord, to file.
Last opportunity to the opposite parties to file reply within 2 weeks. Rejoinder for the next date. The interim order to continue. List on 4th August.
4th November, Your Lordship.
My lord.
Yes.
In this case, my lord, I have already filed the additional affidavit, my lord, stating there in that, my lord, the cases, my lord, pending with regards to prevention of cruelty to animal and also class certain prevention of class certain act, my lord. So many cases, my lord, registered in different police stations, my lord. I have given the copy of the same, my lord, and there are, my lord, as many as 20. 21, 23 cases, my lord, they are after 19, my lord, till 22, my lord. So many cases in my lord, the rampant in the state of Orissa, my lord, cow challan and inter-district and interstate, my lord.
So also the class fluttering, my lord, is also going on, my lord. For that reason, cases are registered, my lord. Initially, the petitioner filed a case before this honorable court, my lord. In that case, my lord, this honorable court directed the petitioner to file a detailed affidavit, my lord, at page 22.
All right. Anyway, you see the
My lord.
additional affidavit filed with the petitioner has been perused. The notice, Mr. Mudali accepts notice on behalf of. Mr. Das accepts notice on behalf of.
Lord, except 7, 8, and 9. Rest.
1 to 6. Notice by issued now to the remaining opposite parties by registered speed post returnable on the next date. List on 5th July, sir.
May I please? These base of cases, my lord, point is one, and this has been already covered by a judgment of this honorable court, confirmed in the honorable Supreme Court. In this first case, my lord, no notice has gone, formal notice.
Oh.
So
All
other
right.
cases, they filed counter.
Okay. I think he'll adopt the same counter.
Yes.
Point is the same.
Point is. Only the first case, there is a rejection order, but other case, second case, there is no rejection order. What they have stated that unless the court directs, we will not give it. Only they have granted the benefit to the cases filed here.
Your Lordship, may kindly take up WPC 27190 of 2021. That is fourth sub-item. There, your Lordship, can see the counter affidavit filed by the registry.
Copy do.
This is about that old pension scheme.
Yes, ma'am. That has been accepted by this honorable.
Then why don't we just allow all these petitions if you have accepted it?
Look, only your Lordship, may I place only counter affidavit of the registry in WPC 27190 of 2021.
We have that.
There, your Lordship, kindly paragraph 8 towards last internal page 5. The line starts with in response, additional secretary. In response, additional secretary to Government of Orissa Home Department by letter number so while conveying and basing of the observation of the finance department has intimated that it is not possible to grant the benefit of inclusion of services of so for employees since they have not in their favor any judicial order for making the old pension rules applicable.
That is the
counter affidavit, internal page 5, just above paragraph 5, paragraph 9. The line starts with in response, additional secretary of Government of Orissa Home Department.
Not possible to grant the benefit of inclusion the services in the pension bill establishment.
They have stated that since they don't have any judicial order, so that's why we will not.
So we now clarify that the same judicial order. You say the only reason why the petitioners have not been given benefit is explained in para 8 of the counter affidavit of opposite party number 5 in the following manner. This open quotation in response, additional secretary to government. Paragraph, it is clarified that the judicial order earlier passed in writ petition civil 15433 of 2012 will be in Anand Dash's case, will be made available to all the present petitioners as well. Consequently, the same directions will stand issued in these petitions. The petitions are disposed of.
Okay. Your first case, my lord, Annex 5 is to be set aside because there is a rejection order. Other cases, there is.
In the first case, consequently, the rejection order.
Annexure 5.
Bracket Annexure 5, challenged or dated 6/8/2021. Challenged in writ petition civil 30957 of 2021 is hereby quashed. Right. Today, sketch map.
Yes, ma'am. I have already filed the sketch map. Last occasion, Lordship directed to file a counter.
Yes, yes, yes.
Additional affidavit. Anganwadi Center. There's already a civil suit pending.
Yes, pending. There is no way out. Last page 18 of the writ application. Lord. They have started that. But page 18. Lord. May I read page 18. Lord.
Yes.
That is the order of the collector. Lord. May I read, Lord? The CDPO municipality Baleshwar submitted PWC that the land is verified by Tahsildar Sadar Baleshwar and proposed the site for construction of AWC building on plot number 14/102 on its letter number show that is 6/2020. The land is suitable for AWC building. There are no school within the service area as Isamnagar. Therefore, as per the supervisor's CDPO's observation, the land is easily accessible for AWC children. Within the service area of Isamnagar AWC, there are no schools, so that Executive Officer Municipal Baleshwar requested Tahsildar Sadar Baleshwar to identify one suitable land as.
Have you seen this additional affidavit?
Yes, ma'am.
I'm just going through it.
Then Padmini Manvi.
Let him take instructions on this.
Yes, ma'am. I have filed to
An additional affidavit has been handed over today in court on behalf of the petitioner. Mr. Das states that he needs time for instructions on the said affidavit. At his request list on 18 July.
24, I pray for some more time to file counter.
All right. Counter affidavit will be filed within 8 weeks as a last opportunity. Rejoined for the next date. List on 16th August.
My item 25.
Yes.
I'm appealing through this thing.
Yes.
My lord, is it item 25?
Yes.
My lord, this is a case where being agreed with the order of passed by the PML adjudicating authority, the petition has challenged before appellate tribunal. But the appellate tribunal is not functioning, for which no stay has been given. Thereafter, this matter has come before this honorable court, and the honorable court has given stay up to today by issuing notice to the opposite party. My lord.
Why is it coming up here? No reply has been filed till date.
My lord, let the order be given that till the disposal of the state petition by the appellate tribunal, this no action should be taken against the petitioner.
No, but who's for the other side, sir?
Yes, my lord, myself. But there is now recently it is the council has been changed. I am in charge of the case just 2 days back. So I have to collect the brief. You will let it come next week so that I will collect the brief.
At the request of counsel for the opposite parties, list on, not next week, sir, let it come up now after vacation on 22nd June before the roster bench. Interim order to continue.
Obliged, madam.
The only short question is at page 7, whether the London IT is justified to allow depreciation 25% on railway and rolling stock, treating the as fixed assets as plant and machinery as against depreciation on 10% allowed by the AO and implementing assessment of treating same building. My lord, this tribunal order and for the assessment 207878 paragraph 24 page 18, his depreciation has been allowed 15%.
It's not building, sir. Rolling stock can't be building.
In the own judgment, 15% is allowed. Paragraph 24, page 18.
the SSC was denied to the higher rate of depreciation on the assets, finding that they are not plant and machinery. But as can be seen from the admitted facts and circumstances case, the fixed assets serve some special purpose of working, and thereby they are considered as plant and machinery in the working process of the SSC. This claim the SSC is fortified by the decision in the Honorable Supreme Court rendered in the case of CIT versus Dr. B. Venkateswar, 243 ITR,
That's
CCI.
it. So we don't interfere, sir.
Page 18, the same 50% may kindly be allowed.
No, but the tribunals, the SSC's own case, the tribunal has done the same
Yes,
thing for the
own
earlier
case,
years, sir.
own case. It put assessment 2078 in ITA 48 of 2011. The second item. The judgment has been quoted in the tribunal order, page 18.
Who's for the Paradeep Port Trust now? On this, we have to issue notice now to Paradeep Port Trust.
Yes.
All right, notice returnable. In all these matters, sir.
Sir, all matters.
Notice returnable 1st August. Same.
Yes, ma'am. And 27 same.
My lord, I am appealing for criminal appeal numbers 745 of 2011. In this case, I have not received the paper book, your lordship. This year transfer appeal, your lordship. The previous council simply filed the appeal with so many delay, so many
The
defects.
appellant is permitted to collect a copy of the paper book from the registry. Who's in the other matter? 574. You are appearing in that also.
No, my lord. Only I am appearing in criminal appeal 745 2011.
Who's in 574 of 2010? Mr. Raman Kanta Patnaik. Your client is on bail.
No, my lord.
He's in jail.
Yes, your lordship. Last 13 years.
Then why are you taking adjournment like this?
My lord, I am not taking adjournment. This is today list for hearing, your lordship. I am not ready for hearing because all documents are not available with me, your lordship.
All right, list on 5th May. You'll be ready by 5th May or 12th May?
Any date, your lordship.
5th May. All right. Notice without process will be issued to Mr. Ramakant Patnaik, counsel appearing for the appellant in the accompanying appeal, criminal appeal 574 of 2010 to remain present at the next date. Messrs. R.K. Patnaik. No, Shri R.K. Patnaik. All right. All right.
May I make a small prayer?
And in 321 of 2011 also, notice without process fee shall be issued to the council to remain present at the next date. Yes, sir.
Madam, may I pardon to make a mention? Today's weekly list item 26, I was there. I was written on the way I could not reach in time. Can I be permitted to place?
26.
26. 27.
Weekly list. So we can't go back there, sir, now.
Now, after the Passover taken up, I will say some Passovers.
No, there are no. Weekly is all over, sir.
I am sorry, I could not reach because I returned on the way.
You file an application, we'll take it up on the same day, sir.
My lord.
All right.
I'm
None appears. This is
item 29, your lordship.
My
lord. Item 29.
Yes.
My lord, this is a case wherein virus of section 34 of the Reprehension of People Act 1951 is under challenge. This honorable court by order dated 8/11/2019 admitted this case with a direction to file counter and rejoinder. In the meantime, counter and rejoinder are already filed. This honorable court by order dated 16/2/2022 has been pleased to direct me to file an affidavit specifically on giving some empirical data that in 2009 there is an amendment enhancing the amount. Previously for contesting a seat of MP it was 10,000. Later on it was increased to 25,000. What was its effect on the number of candidates coming forward to contest election?
Yes.
Your Lordship, in response to that, I have filed an affidavit on 12/4/2022.
Let's see that.
My lord.
Yes.
My lord. From paragraph 234, I am reading it very quickly, Your Lordship. That will make the entire matter clear. Paragraph 2, I have stated that the petitioner is challenging the virus of section 34 of the Reprehension of People Act 1951 as it makes deposit of huge amount mandatory for contesting the election. This creates discrimination among haves and have-nots. As per 2011 census, more than 22% of Indian population lives below the poverty line. That is a family having income less than 27,000 per annum in BPL category.
Again, the arguments. This is not empirical data, sir. This is only arguments again.
Sir, thereafter I have given, sir. Thus, directly section 34 debars this large group of population from contesting the general election. In other words, the spirit of section 34 of the Act 1951 is that a poor man is ineligible to be people's representative only because he is a poor. However knowledgeous or humanitarian person he might be. Thereafter, Your Lordship, the data I have given that it is respectfully submitted that electoral process is the servant of democracy and not the master of democracy. The petitioner tried his best to find out the aims and objectives behind introduction of section 34 of the Act, but no specific aims and objectives for introduction of section 34 of the 1951 Act is there. However, previously a deposit of rupees 10,000 was required for contesting the post of MP seat by general caste people and 5,000 for SC/ST people, which was amended by Act 41 of 2009, which came into force with effect from 1/2/2010, and the amount was respectively changed to 25,000 and 12,500. Also, previously 5,000 was required to be deposited by general candidate for contesting the post of MLA and 2,500 for SC/ST people, which has been amended by Act 41 of 2009, same amendment which came into force with effect from 1/2/2010, enhancing the amount to 10,000 and 5,000 respectively. That it is respectfully submitted that by enhancing the amount of deposit, also the number of candidates have not reduced. The petitioner obtained information from Election Commission Orissa and could get the statistics that in 2009 general election for 147 seats of MLA in Orissa, total number of contestants were 1288. Whereas in 2014 general election, the total number of contestants were 1420.
That's very negligible, sir. There's hardly any difference.
Yes, my lord. I am coming thereafter. Thereafter, I have written, Your Lordship. In 2009 election, the number of eligible voters.
Which paragraph are you reading?
Paragraph 4 of my affidavit, page 3. Affidavit dated 12/4/2022. That affidavit, flag mark has not been done, but it is there in the noting. It is there. Additional affidavit dated 12/4/2022 by the petitioner. The flag mark inadvertently not there. Your Lordship. Hello, paragraph 4 of page 3.
In 2009 election, eligible voters were so much.
My lord, in 2009, it was for 147 seats because these are the number of seats, 147 total in Orissa. It is 1288. Whereas in 2014 general election, it is 1420.
So it's all more or less similar. Para 5 come to para 5.
My lord.
More or less similar, sir. There's no impact at all.
Yes, Your Lordship. That is that I have filed.
There's no impact at all, sir. Sorry.
That similarly.
I'm glad you made this exercise. Now you yourself are convinced it has no impact.
My lord. So the reason is, Your Lordship, by putting some amount as a block, as a check, no purpose is being solved.
No, it is at least remaining at 8,000, sir. Otherwise, it will all go out of control.
My
See,
lord,
we have only so much of a machinery. As it is, you're having some 6-phase election, 7-phase election. It's
Your Lordship,
becoming such a
I have
cumbersome
stated in paragraph
exercise.
5. I have stated in paragraph 5 that in 2009 general election,
Conducting elections is not an easy task.
that I understand, Your Lordship.
Ah.
My lord, Your Lordship, this is an argument I am putting to myself. The Constitution has not prescribed any restriction on age or qualification.
No, it has. It has. I'm sorry, there is a restriction. What are you saying?
Qualification,
You have
Your
to be,
Lordship, educational.
you have to be of certain age.
Yes, Your Lordship, is only minimum
You can't
25.
be 18 years old, you can't contest for assembly election
25.
or MP.
It is minimum 25, Your Lordship.
So
But there is no
there are
educational.
restrictions.
There is
are
no
restrictions.
educational qualification.
See, the only question we have to ask, the only question we have to ask, are these restrictions reasonable?
Yes,
That's
Your
all.
Lordship, that is whole submission. When Constitution doesn't prescribe any educational qualification restriction so far, monetary restriction is concerned, the Constitution doesn't say. Now the restrictions provided under the representation of, Your Lordship, may kindly see, democracy consists of two
They are
things.
crowdsourcing now.
Your Lordship, may kindly see, paragraph
In
5
fact,
I have
many
answered.
candidates very proudly say, even my deposit money, my voters have helped. There are some people who proudly say every person gave 1 rupee. That way, I'm assured of my 25,000 votes. I'm paying 25,000 rupees because of my supporters. Nobody is deterred, sir.
Sir, with respect, my lord, it can never be said that a person will collect money from others to contest. Why a
not?
person?
Why not? It happens, sir. Suppose we all want a candidate to come forth. We all support him in various ways. In fact, campaign funds can be collected from individuals also. Why not?
A person will campaign and will collect.
In fact, it is being collected from individuals.
That is a different thing whether
There are
an
so
individual
many
will give or
candidates who
not.
cannot afford the kind of campaign expenses. I'm saying even if you have to talk of door-to-door campaigning, you have to print some pamphlet, you have to print some material. There are people taking help of others.
Sir,
It's very common.
I don't dispute, Your Lordship. My lord, I
college
admit.
elections, bar elections, everything, all these elections, there is only crowdsourcing.
The question is, Your Lordship, I understand. The question is, Your Lordship, whether people will give me or not is a different thing. It is a question of my right to contest.
If you can't even find 100 people to give you, then where are you going to get 100 votes?
That is exactly my submission. If I am getting 100 supporters, Your Lordship may kindly consider paragraph 5 I have written. I do not say, Your Lordship, section 34 is to be absolutely struck up. That I do not say. If it cannot be, as an alternative, there can be 100 or 200 proposers. There is no harm, my lord. Your Lordship may consider. If a person can deposit money, I don't dispute. Yes. If I cannot deposit and there can be 100 or 200 supporters for me, that I can give as an alternative, my lord, it is not something very illegal. Because my lord may consider democracy consists of two things: right to contest, right to cast vote, and right to contest election.
Correct.
Now there is no dispute that democracy is the basic structure of.
These are not fundamental rights, by the way.
Not fundamental rights. I have never stated a single word anywhere in my rejoinder that it is a fundamental right.
Correct.
I have only stated that democracy forms basic structure of the constitution, and parliament has no power to amend the basic structure of the constitution.
That is all absolutely right, sir.
My lord, the statistics I have given, it has absolute. Your lordship may kindly see, if by enhancing it to 25,000 in 2014 for Lok Sabha, the total number of contestants were 8251. In 2019, it is 8039.
Do you know how much money the candidates on an average are spending these days?
There are, Your Lordship, there are big parties.
I can see Mr. Pitambar Acharya there, who's a senior lawyer. Mr. Acharya.
Yes.
What do you think is the average expenditure by a candidate for a Lok Sabha or even an assembly election? What is a candidate spending these days? Nothing in your own lifetime, sir. It is all added. Zeros have got added.
It can't be quantified by me because Your Lordship knows this.
It's beyond your imagination.
It's beyond imagination. But actually, can I assist me? Your Lordship is right.
Yes.
Jyoti Basu Devi Ghosal, 1982 Supreme Court, So that's clear. It's not a fundamental right. It's a
that is right.
statutory right.
Here it's
Nowhere I have claimed. Nowhere I have claimed it's a fundamental.
To be fair, to be fair to Mr. Mishra, he's not claimed that.
Yes, sir.
Interesting point he's raising, Mr. Acharya. He says
Fine.
if you keep increasing the deposit money, nomination money,
that is refundable, Mila. Your lordship may turn to rule. Where is that? Commencement of the return of section 158, Mila. That has to be read together.
In case a candidate secures
made under section 34 or under that section, read with subsection 2 of section 39, shall either be returned to the person making it or his legal representative, or be forfeited to the appropriate authority in accordance with the provisions of this section, except in cases hereinafter mentioned in this section. The deposit shall be returned as soon as practicable after the result of the election is declared. If the candidate is not shown in the list of contesting candidates, or if he dies before the commencement of the poll, the deposit shall be returned as soon as practicable after the publication of the list one show his death. Subject to the provisions of subsection 3, the deposit shall be forfeited if at an election where the poll has been taken, the candidate is not elected and the number of valid votes polled by him does not exceed 1/6 of the total number of votes. That means, my lord, this is to discourage frivolous candidates to take part in the election. If somebody secures 1/6 of the total number of votes polled, then, my lord, in that case, the person who contests is entitled to get a reform. This is to be read with 158.
All right. Thank you, sir. Thank you.
My lord. That I do not dispute, your lordship. This 158 provision, if a person could not secure minimum number of votes, that is to be forfeited. It is a case after the question of election. My very question is, your lordship, a person wants to contest the election and he is debarred only on the basis of ground that I humbly submit, your lordship may kindly consider, if an alternative is given that 200 proposers, this is exactly the judgment of Ireland High Court. We have borrowed the law from English system, your lordship, from the common law. This is exactly section 13 of the European Parliament Election Act 1997 exactly says the same thing. This was challenged before the Honorable Ireland High Court. Ireland High Court considered this is exactly similar matter. Ireland High Court in Thomas Redmond versus the minister, categorically, they discussed all the provisions under democracy and all the quotations, everything that has been said. Finally, they said that it is desirable and they struck off this European Parliament Act section 13 and section 14 of the Electoral Act 1992, both were struck off. They said that 200 or 100 proposers must be given as an alternative. Only monetary restriction is arbitrary. I do not dispute. Other provisions are there that I never dispute. As an alternative only, this is the only prayer. If a person can get 100, 200 proposers, he can contest. If a person can deposit money, he can contest. It may be given as an alternative only.
Right.
By debarring 22% of population or
No, those are all matters to be decided by the legislature. What kind of further restrictions or requirements must be there? As far as the existing requirements are concerned, the court's task is only to see is it a reasonable measure or not a reasonable measure. That's all. That is the scope of our role.
My lord, the affidavit I have submitted and earlier affidavits, also the written note. I have only stated, your lordship, emphasizing the point that under the constitution, there is no restrictions so far the educational qualification of a candidate is concerned or monetary restrictions are concerned.
Right.
It only prescribes the minimum age limit.
No case and the Jyoti Basu's case, lot of things are taken care of by the Honorable Apex Court.
That's true.
But this point has not been answered.
No, that's true. That's true. We'll answer it, sir. We'll answer it. Sir. Anything you want to add, Mr. Pari?
No, my lord. This it is sufficiently this, my lord, that it is limited. Scope is very limited. Then
all right. Orders reserved, sir. We'll give a judgment. But Mr. Mishra, we appreciate that extra effort you have made.
Sir.
Yes.
All right.
It's a case, my lords. I'm a small industry preparing the wire. Mills, what happened? Mills on 16/5/2002. Mills, the meter was tested. I was supplied. I availed the electric connections from the then SESU miners. There was a meter testing by their square on 16/5/2002 miners. They found it is correct. Meter is okay. Then miners again on 24/1/2003, the MRT square came, found the meter is okay. No, there is no tampering and all this. Then all of a sudden on 30th January 2003, another MRT square verified and found that the cable, that there are some damage, and that is how they allege that yes, there is tampering. That must kindly consider that was made on 24/1/2003 miners. May I submit, madam?
Yes, yes.
30th January 2003 miners. So thereafter miners, I have come before the Honorable High Court, and the Honorable High Court directed to deposit that there was an they saddled me the amount, penalty amount of 21 lakhs. Then the Honorable High Court directed that pay 5 lakhs and you get the electric connection. Admittedly, there is no outstanding due in respect of the present bill. We are continuing miners. Status quo was there, and thereafter it was remanded to the appropriate authority, designated authority, to adjudicate the dispute. The designated authority adjudicated the dispute. We are not satisfied with that dispute. To be very brief, so far as my point is concerned. Then we preferred a petition for the chief executive. Thereafter, we have gone before the OERC. Then what happened? The provision of the regulation, which was prevailing then, that was 95 regulation. Regulation 1995 minutes. 1998 minutes. That is OERC Distribution Condition of Supply Code 1998.
Yes.
There minutes I'm referring to 110. At the point my humble submission is all these claims were raised on the basis of the provisions of that code, referring to the provision of that code. Then I'm referring to the provision of that code referred to in section 110 minus. 110 minus.
There is a code. You have a copy?
So I have that book.
You have the local laws code. Yes.
110 consumer protection. The consumer agreed by an action or lack of action by the engineer under the code may file a representation within 1 year of such action or lack of action to the designated authority of the licensee above the rank of engineer, who shall pass final order and on such representation within 30 days of the receipt of the representation. That I availed and he passed an order. I am agreed by that order. Then I preferred a petition under 2. So
CEO
2.
So CEO also rejected.
That was rejected. That was not attended to. Anyway, I am agreed by that. So then I preferred -3. On receipt of the order or lack of order of the chief executive officer of the
Reference to the
licensee
commission.
on matter is to commission. I have gone before the honorable commission.
Now this is the 4th round. This is the 4th round. After commission, 4th.
After commission, 4th round. But my humble contention is very limited, man. The honorable commission, instead of refused to deal with the matter on the ground that in the meanwhile 2004 regulation come into force, and 2004 regulation and the new act 2003, Electricity Act 2003, provide our alternative manners of the dispute redressal forum to go there and to get it adjudicated. My humble contention, this is a cause of action which arose manners while this regulation was in force, and which the OERC has authority to deal with this and can adjudicate the matter. This is what manners in nutshell the case is. May I submit manners in this case, 2004 regulation. What is saved and what is repeat.
No, what has the commission said in this case?
Commissioner said 2004 regulation come into force. Secondly, manners that new the 2000 it will be governed under 2003 on the basis of a decision of the Honorable High Court, and that I have checked up manners that writ application that is not loaded, that is not available in the website. But fact remains, I found that it was disposed of on admission stage, where the parties themselves said that we will go and invoke that forum. Here in this case, my case is that you have the jurisdiction you can deal with. They are to deal with because it is a pre-2003 act. That is what my humble submission. Here in this case, 21 lakhs they have claimed. In the meanwhile, I have deposited that they reduced the designated authority reduced to 18 lakhs some odd. I deposited around, in the meanwhile, I deposited around 15 lakhs, another 16 lakhs, and around another 2 lakhs or 3 lakhs of rupees is there. But in course of time, my lords, they will be imposing penalty, penalty over penalty, that is interest over the penalty. That is what my lords amount accrued. My humble contention, my lords, I am not placing the matter on so far that factual aspect is concerned, because if my lords I will succeed that, yes, I will go to the OERC, I will place all my cards before that OERC, and OERC can adjudicate the matter and can pass an order on merit. That is what I am not submitting anything about the merit of the factual aspects.
Kind permission, Millard. WPC 39035/2021 identical issue, identical grounds was not already decided by this honorable court, and leaving behind, keeping the matter to refer the matter to be adjudicated by the opposite party. This same is pending.
Oh,
yes. So, Millard, in view of this, Millard, this petition is nothing, no more substance. So already this is merged with this last order which was passed by lordships.
Oh, I have tried to get it, check it.
Specifically,
but it's not there available on the website.
Same Millard thing, same ground, same.
Kindly give me a copy so that I will check it out.
You just see. And it's para 5. So since matter is pending before the Millard, the authority let them explore, and the authority may take a decision. Already there is, because same penal bill, etc. Everything was Millard, and their power was disconnected.
This is not that matters, but thereafter matters I have gone to the I have submitted a representation on understanding. We deposited the amount of rupees 10 lakhs, and they have given me the line. There is no question of disconnection. That part matters is over. Now thing is that
aspect in the shape of
that part is over.
Millard, they have filed the representation.
May submit.
Entire aspect they have not raised. The lordship was directed to take a decision in 4 months from the date of reconnection. Already you have reconnected. So the matter is pending.
Let's kindly visualize one thing. Well, so far that writ application is concerned, I have submitted a representation that my learned friend refers to. I have come before the honorable court because you have raised a penal bill and a penalty over penalty matters interest. That is what matters, whether it is permissible or not. I am not raising that point now. Question is, suppose my lords, I will go there and they will reject it. Then it will be a cause of action.
You will file a fresh proceeding.
My lord,
petition before the then my lords again we are to be brought within the scope of the new act.
That you will cross the bridge when we come to it, sir. Suppose they agree with you and they don't levy any more money, I mean, no more charges, then you will not be agreed.
So then better, it would be better, my lords, if my lords would permit me with a leave, permit me to file a detailed representation so that they will
you already filed, sir. You have already filed.
That they have considered, they have given me my lords electric connection subject to pendency of this writ application. They have given that electric connection. I deposited 10 lakhs, they have given me this connection. with an understanding that is
The
going
bill
on.
was
No,
totally.
no, reasoned order has to be passed, sir.
No, that has not been passed.
So that will be passed.
That order has to be passed. My lords, here in this case, my contention, my lords, and visualize one thing, my lords.
If not so aggrieved, he may file the fresh cause of action comes.
Correct.
The fresh cause of action arises and then I can file it. But question is that I will be brought within the purview of the new one.
That you contest there, sir. Whenever you cross the bridge when you come to it.
So once I may be permitted to raise that point about the maintainability also before that. Before that authority.
All right. You say during the pendency of the present writ petition, writ petition civil 39035 of 2021 was filed by the same petitioner against the Tata Power Central Orissa Distribution Limited bracket TPCODA for an interim arrangement of reconnection pending the passing by the TPCODL of a reasoned order on the outstanding dues against the petitioner.
They have given me reconnection, my lords.
Yeah, pursuant to the above order, the petitioner has received the reconnection. Stop. However, as per the said order, a reasoned order had to be passed in accordance with law and the scheme of the TPCODL within a period of 4 months. Stop. Counsel appearing for the TPCODL states that the said order would be passed very soon. Paragraph, it will be open to the petitioner to make advance all its submissions before in the above pending proceedings, which will be taken into account at the time of passing the reasoned order. So if agreed by such reasoned order, obviously it will be open to the petitioner to seek appropriate remedies in accordance with law.
Obliged, brother.
Only thing, my lords,
All
is
the
that, my lords,
contentions raised by the petitioner and the present petitioner are therefore
No.
left open to be urged at the appropriate stage. The petitioner's disposal.
Passed over matter item number 11.
But item 11, actually, the mediation has failed. If you kindly see, the order has been passed. 2/4/2022.
Right.
Now, in view of the fact that there is an arbitration clause, page 37, well, clause 37.
Yes.
Any dispute or difference of any nature whatsoever, or regarding any right, liability, act, omission, or an account of any parties that arising out of, or relates to the agreement shall be referred to the sole arbitration of the managing director of the corporation.
So you can agree to a name of an arbitrator.
Yes, your lords may kindly appoint one named arbitrator.
Who's for the, yes, Mr. Acharya?
My lord. Your lordship may appoint because in view of that 15 amendment.
All right.
Your lordship may appoint.
Justice A.K. Ratha?
Yes, not this.
All right. The mediation proceedings, the mediation report has resulted in, no, the mediation was not successful. Paragraph. Counsel for senior counsel appearing for both parties leaves it to the court to appoint any arbitrator of its choice to adjudicate the dispute between the parties. The court accordingly appoints.
That is in view of amended provision of section 2.
Yeah, in view of the amendment in 2015 to the Arbitration Conciliation Act 1996. In that view of the matter, the court appoints Justice Dr. A.K. Ratha, the former judge of this court, as the sole arbitrator to adjudicate the disputes between the parties, including their claims and counterclaims. The arbitration will take place under the aegis of the Arbitration Center of the High Court. It will be open to the parties to seek appropriate interim reliefs in the said proceedings in accordance with law. The petition is disposed of. Right. Right.
Passed over matter item number 15.
Maybe please your lordships, my lord. My lord, two villagers, sir, before your lordship,
in this public interest litigation, the life and livelihood of both the villagers are concerned in these two writ petition, madam. Since the time of immemorial, the forefathers of these petitioners have been suffering due to the flood waters of river Mahanadi, my lord. My lord, there is a sweet water lake in the district of Cuttack, that is Ansupa. The perennial water channel connects to the river Mahanadi. One is Mayuri Nola, another is Kabula Nola. At Mayuri Nola, there is a river embankment, my lord, to protect the people from flood. That is in northern side embankment of river Mahanadi. As these two channels, my lord, the flood waters of river Mahanadi enter the river Lake Ansupa and nearby areas. Therefore, a sluice gate has been constructed at Mayurinola on the embankment itself, my lord, that flood water cannot enter the Ansupa. If it enters, it is through the sluice gate, they can control it, my lord. When the Kabula Nola is concerned, my lord, they have constructed, when they started the construction, I filed these two writ petitions, my lord. Previously, one writ petition was there. Their direction was given that to consider their case, my lord, because it has a great repercussion. They constructed it according to them 300 meters away from the embankment, my lord. Therefore, that they did not construct this, they did not intend to construct this sluice gate on the river embankment itself, my lord, on the mouth of the water channel. Now there is 300-meter gap, my lord, in between the proposed sluice gate and the river embankment. When my lord, flood comes in the river Mahanadi, the entire two villages and their paddy fields are submerged in the flood water. Now it will be submerged through the 300 meters wide open space, my lord. Our prayer is that, my lord, let this sluice gate be constructed on the river embankment itself. They say, my lord, in the counter that it is not feasible because that is sandy place. Technically, it is not feasible, my lord. My lord, the engineer who has given that it is not technical feasible, he is now behind the bar, my lord. He has my lord, misappropriated crores of money and found near about 10 crores money from his residence, my lord. Now, my lord, in the sandy place embankment, if one
do you have an expert? Can you arrange for an expert who can bring a report?
My lord, Mr. N.K. Mahati, engineer who is practicing here, he can go, my lord. He has in number of times he has been appointed by
this will require a proper.
I have filed a petition.
Irrigation expert, sir.
This is a second round of litigation, my lord. Earlier, the villagers had approached this honorable court. This honorable court had directed the chief engineer to take a decision which is impugned. The chief engineer has passed a reason order, my lord, saying why the my lord, there is a dispute between two sets of villages with regard to construction of a dam or a sluice gate, my lord. Now the check dam has been constructed, my lord. As on filing of the date of the affidavit in 2019, 50% of the construction was over. So by now, my lord, it must be substantially.
Oh, there is a check dam being constructed.
Yes, my lord. Check dam, Lord Shima, kindly see, we have mentioned in the counter, my lord. The construction work of the check dam over Kabula Nala is now under progress. The construction work of the check dam is almost 50% complete. As on date of filing of the
check dam, we want the sluice gate may be constructed because we two villages, my lord.
Sluice gate is not feasible,
my lord. Another is Anandpur, my lord.
Why they're saying
two villages will be affected after this sluice gate? These two villages will be affected.
We don't know what the effect of the check dam is going to be, sir.
Check effect, my lord. If check dam has been, according to my learned friend, it has been constructed 300 meters away, my lord.
Check dam is 300 meters away.
Yes,
it is a separate.
It has been constructed.
That is a separate check dam. We are not concerned with check
300
dam.
meter upstream the river, because at the mouth of the river, what my learned senior is claiming, it should be a dam must be constructed at the mouth of the river. It cannot be done because technically it's not feasible because it's full of sand. So that is the only difficulty. The grievances have been addressed. There are two sets of villages, my lord.
No, we are
there
not
are 5 sets of villages who are saying that the sluice gate is beneficial for them, my lord, because it is saving them from a flood situation.
No. They are saying why only those 5 villages are helped. Why not us?
We should be protected, my lord. We are suffering from.
If I may place, my lord, if I may place the technical report, my lord, chief engineer's drainage report, my lord, which is impugned, my lord. Yes. That is Lord Shima, find in page 55. I'll place my lord page 55. It's a compliance report which was filed pursuant to direction of this honorable court, my lord. My lord, I'm placing from the second paragraph. Apart from draining the surplus water at Ansupa Lake, this drain helps the farmers to cultivate their land for cultivation of rice and vegetables during Rabi season with the surplus water of the lake. The people of village Ostia put a earthen cross bond on the drain, store water and divert it for irrigating to nearby areas for around 2,000 acres. This earthen bond is usually destroyed in rainy season due to flood water in the river Mahanadi as well as in the drain. They again put it in the next Rabi season by contributing labor and money, and this practice is continuing since long, around 90 years as per their claim. In the year when by any reason they fail to contribute money and labor to put the cross bond, the land remains barren for the season. So the construction of a permanent diversion structure at the location is a long-standing demand of the local people, which will save them from spending a large amount of money and labor, which they have to contribute every year. And on the other hand, this will add to their income and prosperity. But fourth paragraph, to fulfill the demand of the public and for the larger interests of the state, it is felt that a permanent check dam with gate arrangement to control water level is necessary to be constructed on Kabula drain. This structure will facilitate the free flow of surplus water from the lake in the rainy season by the operation of gates, and also it will help in storing water and diversion to the adjoining land for Rabi irrigation. Page 56. This structure is proposed to be constructed on Kabula drain away from the drain mouth outfall to river Mahanadi. As this is not a flood control structure and has nothing to do with the flood of the river Mahanadi, the chief engineer drainage has no authority for construction of any structure for the flood control purpose. As per the order of the Honorable Orissa High Court, the petitioner such and such approach the chief engineer with their grievances. They are the villagers of Anandapur, Santapur. On the other hand, the villagers, namely the farmers of these 6 villages, my lord, has approached the chief engineer drainage and submitted the representation recommended by local Sarpanch and MLA for construction of the check dam at the previous determined place. Both the petition was studied in detail, the area was inspected, and both the parties were heard. Interaction was done with local people at the villages, and all previous record of the case was studied and arrived at the following conclusion. The petitioners of WPC such and such has misinterpreted the check dam with flood control sluice and have also misguided the honorable court. Both these structures are differently designed and the purpose is also different. The check dam on Kabula Nala is a requirement of the farmers of 5 villages, and hence it is to be constructed at a technically suitable location for the purpose. In the above circumstances, it is decided that the check dam on Kabula Nala may be constructed at the predetermined location for the greatest interest of the public. So this covers his benefit more number of villages than the people who are opposing, madam. That's our stand, my lord.
Well, we are not opposing that construction of a check dam. You construct the check dam. We have no objection. I prayed that you, in place of check dam, you construct the sluice gate on the mouth of that Nala.
Sir, it's not so simple, sir. These are all highly technical matters.
They have already constructed.
We should not presume to be experts, sir. When the expert is telling us what is feasible and what is not.
You will also can come to page 21.
Yes.
Already one check gate has been, the sluice gate has been constructed to check the flood water.
So wherever that is possible to be constructed,
here, same structure, my lord.
So we are not experts, so we should not presume these things.
Therefore, I pray, my lord, pray that an expert may be sent, my lord. Mr. Enkemati is an expert, my lord, on that. The number of cases in the Jagannath temple case, this honorable court has also appointed him.
All that is fine, sir. We must have a doubt about this report, then we can ask.
My lord, barrages are constructed on the river bed, my lord. River bed full of Mahanadi, number of barrages have been constructed. My lord, we are a sluice gate. Unless we have been suffering for the interest, my lord. We have been suffering since long, my lord.
So that is possible. Sometimes villagers will have to shift.
Possible, my lord. Number of sluice gates have been constructed on the embankment, my lord. Only this has not been constructed, my lord.
So if it was feasible to be constructed, they would have constructed it. Since there is sand,
feasible, my lord. I have seen, my lord. I have personally seen, my lord. It is feasible, my lord.
How do we?
I have seen personally, my lord. I have gone there. I have seen personally, my lord. I have seen personally, my lord.
That is feasible. Seeing is one thing, sir. This is all highly. They have to test the soil. They have to test the.
My lord, you will also kindly see, my lord, that Subarnapur and this Anandpur. Samantarapur is known as Subarnapur, my lord. That is one of highly educated village in this Cuttack district, my lord.
26 numbers of
similar... Another is, my lord, Anandpur. If this 300 meters according to them is kept, my lord, open, my lord, like the previous years, my lord, flood water enters our village, my lord. Enter our village and submerge everything, my lord. Our cultivation goes, our livestock goes, my lord. We suffer every year, my lord. We are economically now, my lord, at a very poor condition, my lord. If the sluice gate is constructed, let them construct, complete that
my humble
check dam. I
submission,
have no objection, my lord. Your lordship kindly direct that if it is possible, that
that
sluice
is
gate can be constructed, my lord.
You do one thing. The only thing that is possible is if you can get the villagers to commission an expert and let an expert give a report, then we'll put that report to them.
Yes, my lord. Your lordship, my lord, direct that we will do.
26 numbers of, my lord, such constructions have been made on either side of Mahanadi throughout the river, my lord, and water is flowing and no flood situation is there.
Right.
And in all those 26 places, no sluice gate is there, my lord.
The sluice gate is there. I have given one of them, my lord.
We have filed an additional affidavit. We have filed an additional affidavit indicating
The court has
places
perused
where
the
this
report
outflow-
submitted by the chief engineer, drainage, Gandarpur, Cuttack, dated 8 March 2019, when it has been explained that a check dam on the Kabula Nala will serve the requirement of farmers of 5 villages. And that if such a check dam is constructed at the predetermined location, it will serve the greater interests of the public in the area. Stop. Learned AGA appearing for the state. ASC appearing for the state informs the court that such a check dam is already underway. The construction of such a check dam is already underway and will be completed.
50% as on 2019.
Yeah,
Substantial.
and will be completed in the near future.
Substantial progress must happen.
Yeah. Paragraph. Mr. Mohanty, learned counsel appearing for the petitioners, on the other hand, insists that only a flood control sluice will protect the villages Anandapur and Subarnapur. Full stop. He states that the villages themselves will now commission the study by an expert, and the report of such expert will be made available to the chief engineer drainage, Gandarpur, Cuttack, to persuade him to reconsider the decision regarding construction of a flood control sluice. It will be open to the petitioners to submit such a report within a period of 8 weeks from today.
Yes, ma'am.
It will be open to the petitioners to also place and record a copy of such report. Paragraph. If the chief engineer receives such report not later than 12th June 2022, he will take a decision thereon. I think you can give it even earlier, sir.
Yes, ma'am. 4 weeks, your lordship.
4 weeks, yeah. Not later than 15th May, he will take a decision thereon. Not later than 29th May 2022. Stop. It will be open to the petitioners to move the vacation court for urgent orders if required. Otherwise, list this petition on 21st June 2022. Right.